We'll get to a couple of questions here. Justin, this first one is for yourself. It's open to our fellow panelists as well, but Justin, will lead off with yourself. In what ways does access to Section 1782 both benefit and harm international arbitration, in your opinion?
Well, I think just picking up on the discussion that we've just had, certainly if we have broad access to Section 1782, it could increase substantially the costs for the parties that are involved. And part of the discussion that we've just had is trying to have this kind of equality of arms, but it's very difficult, when one party, can kind of open the door to broad U.S. Civil litigation, civil discovery. Maybe that just takes away against what arbitration, really is about, and really kind of tilts it in the favor of, the more, well-heeled clients and that we've, all discussed, maybe have worked for, in various capacities. And so it's both a benefit, obviously, to gain information, but obviously it can have a lot of negative effects as well in terms of cost and time. And so it's really going to depend on the particular case. But this is what I see as principal concerns.
Thank you so much, Justin. And Penny, a quick question for yourself here. Again, it's open to all of our panelists. But Penny, what are the steps that one could take if you felt a party is making an unsafe or unjust privilege call?
Very good question, and very pertinent to the discussion led by John, which I listened to with great interest. I've now picked up a few tips as to what to expect. I think it's very, very difficult. It's difficult because it's quite hard to even understand the privilege calls or know that privilege calls have been made without a privilege log. And as I said before, the privilege log can often be, if it's by categories of documents, somewhat unavailing. And so it is actually important that you understand as much as you can about the makeup of the in-house legal group on the other side, so that when you see, because normally if privilege calls are being wrongly made, people slip up because things slip between the net. So two things. One is to actually understand the privilege calls has been unjustifiable. You need to be very, very forensic in your approach. And if you do think an unjustifiable privilege call has been made, the first thing is to go to the lawyers on the other side and to ask questions that will basically narrow and basically don't give up and don't be fobbed off with the first answer you get, which will be general and sort of how dare you question us, and go back and say no, well, I've asked you a specific question, I need to have an answer in relation to this. And if you don't get a satisfactory answer, then you want to go to the tribunal, you want to raise it, you there has to be some substance. You need to have backed the other side into a corner so that you've got something to go to the arbitration tribunal about. But ultimately, what you want is for the lawyers on the other side, and hopefully acting ethically in accordance with their own obligations, to have to provide you with an explanation as to why specific documents have been withheld. And we've certainly had a lot of success in just taking that forensic route, taking it one step at a time, not giving up, being really dogged in terms of the pursuit, and ultimately the tribunal getting enough interested in the question to say to the lawyers, no, I don't want a statement from your client. What did you guys do? What did you do to police this? What did you do? Who made the privilege call? And ultimately you can ask for either the tribunal or for the tribunal to appoint, say, another lawyer to review the privilege calls, and we've certainly done that in the past, and that really does put the other side into the spotlight, because if you have to have a respected US or English lawyer or civil lawyer who is actually asked to look at the documents with a ruling from the tribunal and direction from the tribunal as to what privilege would be acceptable, and they review the documents. If they then say the privilege calls have been incorrectly made, it does leave a lot of egg on the face of the opposing counsel.
Thank you so much, Penny. I want to try and squeeze in a couple more questions before we wrap things up. Anna, this question dropped in during your segment, and it just asks, looking ahead, do you see the international arbitration landscape developing in the coming months or years? So a brief look ahead in terms of international arbitration.
You know, I think the thing that has gotten everyone most focused right now is obviously with COVID, with virtual hearings. And I think there's going to be a lot of movement in that regard. We've had some successful virtual hearings at the firm. I've heard from colleagues that there have been some other ones. You know, so we'll see how that plays out. But I think that's the thing that people are focused on right now the most. I would actually say that the thing that is probably the second thing people are focusing on, especially those who know about it, is 1782, because the way that the U.S. system works is we have different appellate courts, and if the appellate courts don't agree with each other on a topic, that's when it usually goes to the Supreme Court. And as you saw from the first presentation, there's disagreement on the appellate courts as to whether 1782 applies to international arbitrations, and that split has become more pronounced with the recent decisions. So I expect that the Supreme Court will take that up, most likely, if not the next term, the term or the term thereafter. So I think in 2 or 3 years, we're going to have a Supreme Court answer that question. I don't know what the answer will be, but I think that's something that people are focused on right now as well.
Thank you so much. We'll wrap things up with this last question. John, it dropped in during your segment, and it just asks, do respondents truly have an advantage when it comes to resisting document production?
Absolutely, and in particular, if you have a tribunal that is favorable. One point I didn't touch on, and I'm sorry for that, we jumped into the conversation. Respondents have an advantage in particular because they pick their arbitrator second, normally, so you can get a flavor. If you pick and you know your panel is predispositioned to grant discovery, or if your panel is not, frankly, common law oriented, you can probably limit the amount of discovery you'd actually have to produce. So I would say know your panel is equally important as your parallel proceedings, and I think that everybody would agree with that on this call. Thank you very much, everybody.